Thank you, thank you. Well, they say you should save the best for last, and we decided to put that to the test. Welcome to the final session of the 13th Annual eDiscovery Conference. Give ourselves a round of applause for making it through the conference. Thanks for being with us today. We were a little nervous that less people might be here. Thanks also to the online audience who's with us today. So what are you going to learn in the next 50 minutes? Raise your hand if you are a lawyer in the group, if you're a plaintiff's counsel, if you're a defense counsel. So for the online audiences, we got some hands going up. So how confident are you that you can argue in front of a court like this whether Gen AI prompts should be discoverable or privileged? Do you know what you would literally say? Can you raise your hand if you are a vendor, a service provider that's in the audience? Now we have quite a few of those. Yep, for the online audience, more hands are going up here. What would you do if you were asked to serve as an expert witness, undergoing cross-examination in court, on the stand, except for panic? What would you do, right? Are you comfortable describing to some of the non-techies all those complicated words? And I think we actually do have some judges that are still in the audience with us. How comfortable are you writing your first order about AI? Do you think that you know all the terms correctly? We heard earlier in our keynote about vectors. We heard about statistical numbers. We heard about LLMs, RAG. Are you sure that you can write a proper order? So these four superstars next to me are about to embark on a mock argument regarding just this topic, so that in 2 weeks from now or 2 months from now, whenever this lands on your desk, you're going to be ready to go. Presiding over our mock hearing today is the Honorable Judge Gary Jones, fellow Planning Committee member for this conference. Arguing on behalf of the plaintiffs is Leah Bays, a partner at Robbins Geller. Arguing on behalf of the defense is Tessa Jacob, a partner at Bush Blackwell, also a fellow Planning Committee member for this conference. And serving as our expert witness from the same firm as Tessa, Jonathan Woolley is Senior AI Solutions Architect. We have got you covered. If you notice in the resource section, you will see a ton of cases there. These were all generously provided by Minerva 26, thanks to Kelly Twigger, that's here in the audience with us. And before we start, I want to make one disclaimer. The panelists are not representing their firms, their clients, the court, their employers. When you make one of these mock arguments, you try to put into the fact pattern some interesting topics so that you can maximize the lessons that you're going to learn. So for example, we might say, Leah, your client is going to completely mess up process of service. Or we might say, Tessa, your client is going to completely jack up the litigation hold. We all know that Tessa's client would never mess up the litigation hold because Tessa is the lawyer. But we're here to maximize the lessons that we're learning. And so with those set aside, let's move into the facts of our case. This case is called Sean Singh versus ABC Company. It is a race discrimination case, and it involves 2 rounds of layoffs. Who is ABC laying off? The coders, the programmers in the company. Because guess what? The company thinks that AI can do all of this on its own. Plaintiff Shaw was terminated on October 1st. Plaintiff Singh was terminated on November 2nd. And yes, there is a reason why those are 2 different dates. To maintain confidentiality about the layoffs, the chief HR director created a Teams channel, 2 Teams channels actually. 4 people were supposed to have access to this team channel. And whenever you hear the word supposed to, you know exactly where this is going. And that brings us to the hunk in the middle of this slide. This is Nestor. Nestor graduated from the University of Florida, as you can see from the diploma in the background there. He's an analyst in the HR department, so in the talent team, and he wears his University of Florida tie to work every single day. He was asked to build a spreadsheet for the layoff committee. So who should be fired first? Of course, we should have some names, salaries. Maybe we have some performance ratings, bonuses. And of course, with all of this PII, absolutely nothing could go wrong, right? Nestor had an aha moment. He decided that he's going to use Copilot to help with some of the useful comparisons and analysis. You can certainly all see where this is going as well. And let's look at some of the prompts that he was using. I'll give you a few seconds to glance through. Nestor wasn't trying to break the law. He's trying to be efficient. He's trying to be impressive. And so maybe here we launch our first polling question. You can take your phones out. Are you adding AI data, so prompts and responses in your discovery requests? When you send a request, do you ask them to give you prompts and the responses? Or if you're the person who's asking for the prompts, do you actually get those? We're going to look at the answers to that poll at the end of our session. And so with that, ladies and gentlemen, I would literally please ask you to stand up out of your chairs right now because the judge has arrived. All rise.
Good afternoon, everyone. Please have a seat. So we have this afternoon the case of William Shaw and John Singh versus ABC Company. Leah Bays is here and represents the plaintiffs, Mr. Shaw and Mr. Singh, and Tessa Jacob is representing ABC Company. And there are three motions that have been filed. There's plaintiff's motion to compel and for sanctions. And plaintiff, Ms. Bays, is seeking production of the Copilot input, the prompts and the output performed on October 1 for the second round of RIFs, the reductions in force. And she also seeks sanctions relating to the Copilot data generated on September 1 for the first round, which ABC represents is no longer available. Separately, plaintiffs are moving to compel production of AI prompts generated through use of a commercially available AI review tool that ABC utilizes in producing documents to produce documents in response to the RFP. First, we'll briefly hear from Ms. Bays and then from Ms. Jacob, and I'll give counsel an opportunity to provide further responses, and I understand we're going to have testimony from an expert. So, Ms. Bays, let's hear from you first.
Thank you, Your Honor. This is a straightforward discovery dispute. My client was wrongfully terminated on the basis of race. The company assures us this was merely a neutral, data-driven process. Plaintiffs have requested documents related to the decision-making process and reasons for the termination. In this case, that includes input and output from ABC's generative AI system. We know that HR analyst Nestor assembled a spreadsheet containing employee names, salaries, performance ratings, bonuses, age, sex, and race, and then handed it over to Copilot, a generative AI tool, and said, in essence, here, you make the decision. You tell us who to fire. They ran scenarios, they modeled outcomes, they asked for recommendations as to who to terminate. The prompts entered into Copilot and the outputs generated by Copilot squarely fall within our request for production. Now that we've asked for them, defendants are saying, oh, that's not relevant. Actually, it's privileged. And most recently, wait, it may not even exist anymore. The prompts here are relevant. They reveal what HR asked and AI to consider. That matters. It shows what the decision makers cared about. The outputs, also relevant. These outputs were generated for the Reduction in Force Committee. Their purpose was to recommend who should be terminated. That's just not experimenting with technology. These are business decision makers. They may not, we're being told that they did not rely upon the AI generated recommendations in whole, but that does not mean that isn't relevant. If they considered it in any way, it is relevant. Now defendants say that it's privileged. They say that it is protected by attorney-client privilege. We know that the first set of the prompts were generated solely by HR analyst Nestor. He is not an attorney. There is no privilege. For the second wave of terminations, in-house counsel supposedly had some input into the generation of prompts. That doesn't automatically make it privileged. Attorney-client privilege protects legal advice, not business strategy. Just because you copy an attorney on an email doesn't automatically make something privileged. That's what's happening here. The purpose of the prompts was to obtain recommendations about who to terminate. That is a business decision. These are not privileged and they must be produced. To the extent there was privilege in here, the privilege has been waived. These prompts were transmitted into Microsoft systems, into Copilot. This is a third-party generative AI program. Once you voluntarily disclose information to Microsoft, you can't claim that that's privileged. Everyone knows these Gen AI providers retain your input. They use them to continue to train their models. They can be incorporated into the output within the company and then outside the company. I have read the privacy statement on my Copilot, and basically there is no privacy. They own my data. You cannot claim that this is confidential legal advice. Now, again, they're now saying that maybe this information doesn't even exist, that the outputs, the inputs and outputs are ephemeral. If that's true, that raises serious spoliation concerns. These materials were created as a part of a corporate decision-making process. The company received a right to sue with preservation demand on December 1st. This is just a couple of months after the layoffs began. At this point, the duty to preserve was unmistakable. If these inputs and outputs do not exist anymore, then sanctions must be given. No information about the decision of the termination decisions should be entered into evidence. Thank you, Your Honor.
Thank you, Ms. Bays. Ms. Jacob, we'll hear from you.
May it please the court, Tessa Jacob on behalf of ABC Corporation. Your Honor, plaintiff's request is nothing more than a fishing expedition. As far as relevance is concerned, the theory completely fails. Copilot did not make the termination decisions. Humans did. Key facts that the court should focus on are that Nestor was not a decision maker and not on the RIF committee. For round one, his Copilot information wasn't even considered. For round two, his Copilot information was reviewed, but it was not relied on for the final decision. The RIF committee made independent termination decision based on human judgments, not on Copilot data. And as far as the attorney-client arguments that it's been waived, an assistant general counsel assisted in drafting the prompts. He specifically created prompts reflecting his framed legal arguments and relevance considerations. The prompts were created to support legal advice regarding workforce risks. And the purpose was not ordinary business. It was to make some advice, the RIF committee, on legal decisions. As far as the waiver by the use of enterprise Copilot and the spoliation of round one data, we have an expert here, Your Honor, that we'd like to call, and also that you've asked for us to give the court additional information on Copilot. We have an expert here.
Yes, you can go ahead with Mr. Woolley. I think that will be helpful, so the court will better understand the safeguards in Copilot and how Copilot really operates. So go ahead, Ms. Jacob.
Okay, I'd like to call Jonathan Woolley, please. Bailiff, will you swear him in?
Mr. Woolley, can you raise your right hand, please? Do you promise to tell the truth, the whole truth, and nothing but the truth?
I do.
I,
Hello.
Can you please state your name and employer for the record?
Sure. My name is Jonathan Woodley. I am an AI solutions architect at ABC Forensics.
Great. And can you briefly tell us how you became familiar with
Sure.
Microsoft Copilot?
I've been using Copilot for several years. Our consulting firm had an engagement with Microsoft prior to Copilot being released. So we've been familiar with the Copilot workflow from the very beginning before it was even released to the public. I work on it daily. I work with our consultants and then our companies that we work with daily. I'm familiar with Purview, e-discovery, the workflow process for Copilot, and then how it interacts with Entra ID, and that how it controls then the access that you can gain through Copilot.
Okay. We're going to go through things in detail, but I want to just first start by, can you just tell the court at a high level, how does Copilot work?
Absolutely. So the user will write a prompt, and at that point, it gets sent to Copilot service to check and see what access the user has. So this will check Entra ID to ensure that the prompt they are asking can actually be, the response can be given back to them. So Copilot checks access. At that point, it decides what relevant data is it going to pull. Is it going to go to the web? Is it going to pull from your work data from Graph? Or is it going to pull in some sort of combination of the two? Once it gets that information, that is sent to the LLM to process, and then that information is then sent back to the user.
Okay. There's a lot of use of the word grounding. Can you tell us a little bit about what that means?
Sure. Grounding is the information that is relied upon for the response. So there is a broad set of data that Copilot is trained on, as well as your Graph, Microsoft Graph data. And then your prompts are then grounded in that data. So the responses given back come from that type of data.
Okay. Are there different versions of Copilot? And can you kind of tell the court a little bit about that?
Absolutely. And this is very key. There are several different versions. The first one is the consumer version of Microsoft Copilot. This is what you would get with a personal account. So if you have a personal Gmail account or Live account, you can go sign up for this yourself. It comes through Microsoft Edge. It comes through an app that you can install on your computer. There are no governance or Purview e-discovery abilities through this version. There is the Microsoft 365 Copilot, which is the enterprise paid version. So this is a license that you pay. It requires a monthly fee on top of the typical license that you have for Microsoft. It's integrated into Word, Excel, PowerPoint, Outlook, many different places. I can pull data from SharePoint as well. This is fully governed by Purview, has full retention, e-discovery availability. The last is Microsoft Copilot Chat. So this is an enterprise version, but it is not paid for. So this is a version that Microsoft is giving to you with your other E3, E5 licenses. It does not have Microsoft Graph grounding. So it does have access to the web. You can use it by uploading your work documents into that side, but there is no Graph grounding for it. So it has web experience. It is chat only, but it does have the Purview, e-discovery, and the same retentions that the paid version has as well.
And just to make sure we stay on time, I'm going to skip some of these, but you can quickly tell the judge, what are we looking at? Is this the...
This is the personal version. You can see very clearly it's not asking for work data. We see the work data here in just a second, or the work window. It looks
and these two?
These are the two different versions on your computer. You can possibly have two. The Microsoft 365 Copilot is the work version, and then Copilot at the bottom is your personal version.
Okay. And then I think we've gone through this. We're going to skip this if that's okay. Why don't we tell us, what are we looking at here now? What is that telling us?
Absolutely. So this is the enterprise paid version of Microsoft Copilot. A couple things to call out. In the paid version, you have the work and web toggle at the top. So that allows you to search all of your work data, all through Graph. So you can search your email, Teams, SharePoint, anything in OneDrive. The website is essentially a glorified Google search. A little bit more to it, but for sake of explanation, that's where we are. The arrow is pointing to a green shield. That shows enterprise data protection. There's a couple key pieces to that. So the enterprise data protection shows that your data is protected. There is an agreement that your company has in place if you have a typical E5, E3 license that Microsoft says this data is yours. So in this case, the prompt is yours, the results are yours. The prompt and the results are not used to train the underlying models. The data is not shared with any advertisers, and it is treated as your customer confidential information.
Mr. Willett, can I interrupt? Is there a difference between the consumer version, the enterprise unpaid version, and the enterprise paid version in terms of the data protection?
Great question. So the enterprise data protection, or EDP, applies to the work versions only. So it applies to the paid for and the free enterprise version. It does not apply to the consumer side in any way.
Thank you.
I'm going to back up on this one, Mr. Woolley. When you're using the work button, I understand you stated that it looks at the users or has ability, whatever the user has access to, it will look at, correct?
Correct.
But will it also go to the web?
Correct. So as you can see the toggle in this screenshot that you have the ability to turn a work or the web search on or off on the work toggle.
Okay. And this looks really kind of crazy, but I'm hoping that you can help explain where we're going with this.
There's a lot going
just
on.
Step by step,
Sure.
just easy there.
Yep.
I don't think I have a pointer on this, do I? Oh,
You can see at the very beginning, the user prompt gets processed through Copilot. At that point, it is sent to the large language model very briefly. It then decides what data needs to be returned. Do I need to access the web for this? Do I need to access graph? Or is it some sort of combination of the two? So the prompt then is looked at, bits and pieces of that prompt are pulled out. It takes into account the attachments that you add into Copilot as well. And then it decides, I need a little bit of work data. Maybe I need to pull some email out for this, or I need to pull something off a calendar. And then maybe your prompt included something about, traveling to Chicago next week. Do I need some sort of an umbrella or a coat? And then it will access the website as well to pull that back. All of that is sent back through the large language model. The processing is done, and then it is returned back to the user.
During this process, especially when you mention that it goes to the large language model, it also goes out to the web. Are any of the prompts or the information that's inserted in there, is it shared with anybody else? Can someone else see what we're doing if you're using the paid version?
With the paid version, no. It is discoverable. It is saved in Purview, but another coworker cannot see your prompt or see the results back.
Okay. And then what exactly is retained then?
So the retention is the actual prompt itself. It is where the process went through to actually get data. Did it go to the Bing search index? Did it go to SharePoint? Did it go to email? So those pieces are retained, as well as the actual attachments itself.
Okay. There is one interesting point. This is not what I would normally ask this witness to do, but I thought it was interesting, something we should share. Jonathan, when you and I were prepping for this, and I asked the question, you said data protection. That means whatever I put into the prompt, nothing is seen by the outside world. But you gave me one example, which I think everybody in this room should know about.
Sure. So you can see there was a prompt run. Over on the side are our sources. So you can see the sources that were taken into account for the response back from Copilot. It's important to understand that whatever you have inside of this M365 window, that's all underneath your enterprise data protection agreement. So all of that resides inside of your tenant. It is your data. It's your response. But some of these sources are highlighted in yellow. So those are actually web responses back. When you click on one of those links to leave Copilot and go possibly review what was there, you're leaving enterprise data protection. So you are outside the boundary. Where that comes into play is there are companies that will monitor websites and see who's hitting this website frequently. They see that a law firm who deals with M&As is repeatedly hitting this company's website. Hey, maybe that's something I need to pay attention to. There might be something coming. So while you are inside of Copilot, all of that data is protected. It is safe. It's inside your enterprise data protection. As soon as you click on a link to leave, then you are not.
Interesting, right? Okay, back in role play. Can Copilot retention be configured by a company? And is it configured separately, like email, chats? Is that different? Can you explain that, please?
Yep. So it can be configured separately. So you can have Exchange set for one policy, Team set for another. For Copilot, you can drill all the way down to intra-ID groups. So you can say this specific group can be retained for these number of days, while this group maybe gets no retention for some reason.
Okay.
So yes.
Does ABC company have retention settings on its Copilot?
They do.
Okay, and what is it?
3 months.
3 months, okay. And can Copilot data be put on a legal hold?
Yes. When a legal hold is in place, the mailbox itself is put on hold. Your Copilot chats are all saved inside a hidden folder inside your mailbox, a hidden folder that you can't access. So they immediately go on hold.
Okay.
Can I ask a question here on retention? So there is a built-in 3-month retention policy on the Copilot data. Here, that would have, it looks like for the September 1 round, that would have ended on December 1. That coincides with the date that the hold was placed on it. When is the data actually permanently removed?
A great question. So the Microsoft has jobs that will run, and at the end of the retention period, they have a job that moves that prompt to a substrate folder to be deleted. Depending upon the timing of those jobs, it can be run within 1 day. It can be run up to 7 days later, and then there is a possibility that it could be extended 7 days more. So depending upon when the request was made for hold, it may or may not be in that extended substrate folder.
So the permanent deletion may have happened the day after December 1 or up to 15, 18 days after, depending on how Microsoft was handling the data. Is that
Correct. And there is no control over that extended period of time.
Thank you.
Mr. Woolley, in this case, when Nestor's email box was put on hold, was the Copilot data for round 1 available on December 31st?
No, it had been removed already.
Okay. Nestor testified that he used Copilot in relation to round 2 RIF on October 7th. Is that data available?
Yes.
Okay. And the prompts and responses, can you get those out of Purview?
Yes, you can run the Purview reports and you can see prompt and responses.
Okay. At this point, we're going to pretend we hand that over. You will see here a little bit, the export where you're seeing the spreadsheet is so wide, I couldn't put it in here, but it is in your resources. We have a template of what it looks like. Okay. Your Honor, I have no more questions for Mr. Woolley.
Okay, thank you. Maybe we should go ahead for the sake of time and address Ms. Bay's request for the prompts as part of the review. Why don't we hear from you on that, and then I'll hear briefly from you, Ms. Jacobson, and then I can issue my ruling.
Thank you, Your Honor. This may be a case of first impression, but it is not a case without doctrine and without precedent. The question before the court is simple. Are GenAI prompts used to identify documents likely to be responsive to plaintiff's request for production, protected opinion work product, or are they simply another type of search methodology, like search terms, which courts have repeatedly held are not protected work product and must be disclosed? The answer matters, not just here, but for the future of discovery. And the answer is clear. Prompts used to locate responsive documents are just a modern form of search methodology, not protected mental impressions. Defendants are saying that this is like a document review memo. That argument fails. You may give your GenAI tool a name, you may like it better than your regular colleagues, but this is not instructions to an attorney to help them make legal decisions. It is merely something that sets forth a criteria, queries the data corpus, and brings back things that meet that criteria. That is not legal in judgment. That is not instructions to an attorney. That is not mental impressions. Now, review memos may also include information about what might be privileged, what might be hot documents, things like that. That is not what we're asking for here. So we can put that aside. We are only looking for the criteria as to what is responsive or non-responsive in this case. Prompts used for responsiveness are functionally like search terms. Courts have consistently held that search terms and other search parameters such as sources, custodians, they are not opinion work product. They merely reflect the fact of what was done or will be done to locate responsive documents, not why or how counsel believes a case should be won. Although this is a different form of technology, Gen AI prompts used to identify responsive documents serve the same function as a keyword search. Defines criteria, applies that criteria, returns candidates for human review. Calling it a prompt instead of a search string does not change the practical function or its legal character. The rules of civil procedure support this transparency. Rule 34 requires parties to state objections with specificity and to disclose when they are limiting searches by date ranges and sources. The advisory committee notes make it clear that disclosing limits controlling search facilitates informed discussions regarding responses and objections. Prompts used to cull or identify potentially responsive documents are exactly that. They are limits controlling search, and search criteria has never been treated as protected work product. Discovery may be party driven, but it is not supposed to be a black box. Courts have repeatedly emphasized cooperation and transparency are essential in achieving proportional discovery. The producing party may choose the methodology, but that methodology has to be reasonable. There is no way to assess the reasonableness of this search methodology without any transparency. Search terms are disclosed so the parties can collaborate and refine them prior to running the searches. Prompts are no different. Prompts are nuanced, perhaps more nuanced than keywords, and the devil is in the details here. If prompts are shielded from disclosure, there is no meaningful way to assess whether or not it is reasonable. They can lead to costly do-overs and delays. I understand that the court is probably worried about the chilling effect, but that is not the case here. Defendants argue that requiring disclosure of prompts will discourage the use of Gen AI in discovery. The history shows the opposite. Requiring disclosure of search terms did not eliminate the use of keyword searches, quite the opposite. Search terms have persisted precisely because they offer balanced transparency and predictability. Requesting parties can understand the contours of the search, while the producing parties can retain control over the review. Similarly, transparency around TAR did not eliminate the use of TAR. Any sort of perceived lack of use of it is because the transparency waned. And the only thing that was at the end that you could get any insight into it was because of the validation. And that is where the disputes remained. That will end up being the same problem that we have with Gen AI if there is no transparency into the prompts. Balanced transparency, like search terms, is what will encourage adoption. Opaqueness will just breed conflict. The court need not decide whether or not all prompts are discoverable, only the ones to identify responsive documents. They function exactly like search criteria and concern the factual steps taken to locate responsive documents, not counsel's mental impressions. That ruling aligns with the decades of e-discovery precedent and promotes fair, efficient, and cooperative discovery. Thank you, Your Honor.
Thank you, Ms. Bays. Briefly, Ms. Jacob, let me hear from you on that issue.
Thank you, Your Honor. Plaintiff's analogy to search terms and prompts is legally and functionally wrong. Search terms are objective, they're often negotiated, and they do not explain why a document is responsive. On the other hand, document review prompts are written by attorneys. They encode legal judgment. They reflect how counsel interprets defense's relevance and responsiveness. This is classic opinion work product and entitled to the highest protection. Courts have never required production of review protocols or responsiveness memorandas, attorney training materials, coding manuals. Calling these materials now prompts does not change their nature. Also, as to plaintiffs' arguments about transparency, and this is nothing more than a black box, I would disagree. Just like we've done previously with TAR, we have available to us statistics like precision and recall. And we have also already provided things like custodians and date range and sources and the fact that we used AI. So we are not required under the law to to reveal attorney reasoning, responsiveness frameworks. Like, we don't go until we don't turn over our review guides. And a lot of document review involves attorneys working with associates on, is this responsive? Why is it not responsive? What are we looking at? And just like we heard earlier today, there's a little person inside that Gen AI, and it doesn't matter now. Like, we should not have to produce those. As far as the chilling effect, I mean, requiring that lawyers turn over their prompt guides that they've created with a lot of different iterations and a lot of back and forth, it's going to penalize parties that want to adopt new technology. It's going to discourage us from involving AI in our tools. More clients are going to tell us we're not going to use it. So pushing legal analysis back into way back when, right? Like, we want to move forward, and any type of ruling that would require that all Gen AI prompts be turned over, I think will chill the effect. So in conclusion, Your Honor, we're going to say that, deny the motion, protect the attorneys and their use of AI, and encourage attorneys to use AI.
Okay, thank you, Ms. Jacobs. Both sides have presented very compelling arguments, both on the motion to compel, the motion for sanctions, and of course the motion that you just argued, whether the prompts used in the AI review should be produced. So here is the court's ruling and how I view these issues. And first, I want to address the motion to compel the round 2 AI Copilot documents. And Ms. Bays raised relevance. Ms. Jacobs says it's not relevant because the decision makers did not rely upon the information produced by Nestor. I do find, though, that even though the committee, the RIF committee, did not rely on the data in the round 2 decision, that his Copilot work was reviewed by the RIF committee. So to that extent, it is relevant. Similar to when you have an expert in a case, you provide a wealth of material to the expert, and the expert simply saying, well, I got 10 things, I read 10 things, but I'm only relying upon 3, doesn't mean the other 7 aren't relevant. So I will find that that data is relevant. But that leads us to the next question. Even though the round 2 Copilot data is relevant, is it nonetheless privileged because the Assistant General Counsel was involved with Nestor in creating the prompts? And that raises 2 issues. Is the involvement of counsel in creating the prompts protected by attorney-client or work product privilege? And if it is privileged, was that confidentiality lost because Nestor used the work button, or because the AI, the Copilot, may have used through the LLM the web? Has that ruined confidentiality? As to work product, the first question is, was this in anticipation of litigation? And based on these facts, it was not. So when the second round of information was produced, there was no threat of litigation, no notice of litigation, there wasn't a charge of discrimination. So because it was not in anticipation of litigation, the work product privilege would not apply to that. But that leads us to the real critical issue: was the round 2 data protected by the attorney-client privilege? And the attorney-client privilege is somewhat limited, but it has to satisfy essentially 3 things. One, was it a communication between a client and his attorney? Was the communication intended to be and kept confidential? And lastly, was it for the purpose of obtaining or providing legal advice? First, whether the prompts were communication between a client and an attorney. Well, it was a prompt engineered by Nestor, but the facts show us that the Assistant General Counsel was involved in the creation of the prompt. In fact, Nestor was directed by his general manager to involve in-house counsel in creating the prompts. So arguably, I'm not sure what they discussed, but arguably, the attorney was providing legal input into the preparation of the prompts. Now, this is distinguishable from the case we've all heard about, United States versus Hepner, where Judge Rakoff found prompts created by an employee, but without the knowledge of the attorney, but then subsequently provided to the attorney, were not privileged. Here, it's different. The Assistant General Counsel was involved on the front end with the employee in creation of the prompts. Secondly, were they created for the purpose of obtaining or providing legal advice? And the answer in my mind is yes, because the client requested legal input from the attorney in crafting the prompts. There was a specific request by the general manager, get the in-house counsel involved with Nestor in creating these prompts. So that was for the purpose. You didn't have the lawyer there just because the lawyer was good at prompts. You had the lawyer there for the lawyer's input and advice. So it was for the purpose of providing legal advice. And importantly, were the prompts intended to be, and in fact, kept confidential? And on that, we've heard expert testimony that Nestor used the work button plus the co-pilot that ABC had was the enterprise paid version, which has on it enterprise data protection, which shields and protects the data and satisfies the requirement that the communication be kept confidential. So it was protected. It was not used to train the LLM. That's part of the data protection. And it was protected from third parties, in fact, even other employees within the company from accessing that data. So therefore, the round 2 co-pilot data in the court's view is privileged, and the plaintiff's motion to compel production of that data is denied. Now, as to the motion for sanctions, and this relates to the round 1 data, and the round 1 data under the document retention policy in place under co-pilot ended on December 1. December 1, there was notice of the right to sue, and a hold was put on at that point. Now, the first question is, when was that data deleted? So if the document retention policy is December 1, does that mean it was deleted at 12:01 a.m.? And arguably the letter giving notice of the right to sue and the hold was placed later that morning, so the data was lost. We did hear some testimony, however, from the expert that even though the deletion of the data arguably occurred on December 1 from Microsoft's end, that might not have happened until the next day or possibly even 15 or 18 days later. While that's troubling that the data was there and arguably would have been accessible through mid-December, the hold was not placed on Nestor until December 31. Well, that was sufficient to preserve the round 2 data, not sufficient to preserve the round 1 data. But in my view, the delay in placing the hold on Nestor was at most negligent. Haven't heard anything where that was intentional. And therefore, in my view, I find that the motion for spoliation is also due to be denied. Now, lastly, and this is sort of the million-dollar question here, the motion for discoverability of the review prompts. And I will say that counsel for the plaintiffs made some very, very compelling arguments why that should be produced. But in my view, it is something that does fall within the work product privilege. And here's why. First, an AI prompt is different, in my view, from a keyword search. And it's even different from using TAR. The way a prompt works and the way it effectively works is through the input of the mental impressions of the lawyer. It's not a static tool, and without the lawyer's thinking about the case, it's not going to work properly. So in my mind, it is pure opinion work product, the mental impressions of the lawyer, and for that reason, I believe it is protected by the work product privilege. Also, in my view, to not find that those AI prompts are protected really would have a chilling effect on counsel. Think about it for a second. If all of your prompts had to be produced to the other side, like keyword searches are shared, who's really going to use AI? So it does certainly has a real chilling effect. Now, Ms. Bays made the argument that to not allow her to review those prompts will go against having cooperation and transparency in e-discovery. And as we know, that's a very important thing. But it's really like any other e-discovery where the rubber meets the road is in validation and through cooperation. And that can take place even without disclosure of the prompts through possibly sharing some sampling of documents in the null set. Also, the AI review has metrics behind it that can be shared with plaintiff's counsel to give them some comfort that indeed the relevant documents have been identified. And then in a last case scenario, if there are issues on that for some reason, the court always has the option of doing an in-camera inspection of a small sampling of the documents to assure the court that indeed relevant documents have not been excluded. So holding that these review prompts are privileged, I don't think is going to really impact cooperation or transparency. And it is, like Ms. Jacob argued, review prompts are very similar to a review memo that would be created and given to a review team. And clearly, that kind of information is work product. So for that reason, the motion is also denied.
As we conclude our session, I hope that you found lots of value, whether you're a plaintiff, whether you're a defense counsel, whether you're a judge or even an expert witness. Professor Hamilton, thank you for the opportunity on behalf of our group to be able to conclude the conference with this presentation, and we hand it now back over to you.